Welcome back, everybody, to Public Law. In this lesson, we're going to talk about the structure of the UK's government. This is going to be an overview lesson for us to get a better understanding of the various different institutions and processes that we're going to be exploring as we carry on exploring and examining the UK's constitutional framework and UK constitutional law more generally. So we're going to take a formal look at the structure of the UK government. We're going to talk about the concept of the separation of powers. We're going to examine Parliament. We're going to examine Parliament as a bicameral legislature and the principle of bicameralism within the parliamentary process. We will talk about the role of the Crown and the royal prerogative in brief detail as well, before we talk about the executive, the government itself, the Prime Minister, the role of the executive and the cabinet, and then finally we will talk about the broader executive, which is sometimes described as the civil service. So, the concept of the separation of powers is something that we will explore as time goes on in more detail when we look at the principles of the UK Constitution. But within the broader corpus of constitutional theory, this is a very liberal idea which derives again out of the Enlightenment and a number of different Enlightenment thinkers. And it's the idea and the concept that what really ought to be the case is that power should be separated between the various different institutions of government. And the reason for this is to ensure that no one person, or as more likely the case in some circumstances, no one institution becomes too powerful, and as a result of which could establish itself as a formal dictatorship or totalitarian state, all of which would not be great for the concept of the separation of powers and the concept of democracy. And so as a result of this, many constitutional frameworks around the world opt to establish this idea of a separation of powers, and power is usually in this context divided into three modern concepts within the constitutional framework. You often have a legislature, an executive branch, and a judicial branch. And the reason for this is so to ensure that these are the three kinds of authorities, the three kinds of powers that government has within a constitutional setting, and so as a result of which they are separate and should be divided amongst themselves, such that no one institution has the ability to have legislative, executive, and judicial power all at the same time. So what do these things actually mean? Well, when we talk about the legislature and legislative power, the concept of legislative power relates to the idea of passing law, the idea of making law and making legislation. So in the UK's constitutional framework, the remit of this is obviously done through Parliament. Parliament has the authority, the sole authority in fact, to make and pass law. The executive branch is responsible for the enforcement of law, and the executive branch exists in the form of the UK's government, the executive branch itself, so the Prime Minister, government ministers, etc., 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 as well as the civil service more broadly. The judiciary is of course situated and housed within the various judges and courts that exist in the UK's constitutional setting, the highest of which being of course the UK Supreme Court. There are various other courts of appeal that exist as well within this process, and the judiciary is responsible for the interpretation and the application of the law. They apply the law to facts, they interpret legal precedent, they interpret legislation that has been passed by Parliament. So the idea here is that the concept of the separation of powers instills the fact that those who make law should not also be the people who enforce the law and then also interpret and apply the law. They should be separate. And in the UK's constitutional framework, we will see in future lessons' time that the separation of powers is relatively limited in the sense that we have a fusion of the legislature and the executive branches of government, and the judiciary is only separate to the extent to which there has been a separation formally with the establishment of the Supreme Court in 2009. But that there were also institutions and offices which branched all three of these different distinct branches of government. For example, the role of the Lord Chancellor had significant authority in all three, in fact, in the legislature, the executive, and the judiciary. He was the head of the judiciary, he was a speaker in the House of Lords, and he also sat in the cabinet, making him a member of the executive branch. Of course, this is a stark contrast and a stark violation, if you will, of the concept of the separation of powers. So this contrasts, in fact, to the formal jurisdiction and the formal separation of powers, which can be enshrined in various different codified constitutions. One notable example of this is, of course, the United States. The United States has a codified constitution which clearly sets out the powers of each of the branches of government, and as well as this, sets out the authority and power that one branch of government has over the other branches of government. This is known as a system of checks and balances. The way here is that not only is power separated across these three institutions, and the institutions are clearly separate, but in addition to this, the institutions can also have power over each other, such that no one authority can have too much power because it can be checked by the other two branches. There are various examples of how this works in the United States. For example, the legislature, the Congress, has the ability and the power to make law, to make legislation, but the president has the power to veto that legislation. And so that is representative of a check that the president has over the Congress, over the legislature. But then as a representation of the check that Congress has over the president, if the president vetoes a piece of legislation, then Congress can actually override that veto if they have enough votes. And so you can see there, just in one process, the process of passing law, that there are multiple checks on both from both situations in terms of branches of government. In addition to that, the Supreme Court in the United States has the power to check the legislature as well, because it has the power to strike down any law that is unconstitutional. So if Congress passes a law that is unconstitutional, then the Supreme Court can say, no, this law doesn't exist. This law is wrong, it's unconstitutional, it is no longer enforced. So these are the various ways in which checks and balances can be enshrined within the US system. Compare that then to the UK's system of separation of powers, where we have a significant limitation. Before the implementation of the Constitutional Reform Act, the 2005 Constitutional Reform Act, before it was formally implemented, i.e. the Supreme Court was opened in 2009, all three branches of government sat in Parliament. The highest judicial office was the Lord of Appeal in Ordinary, which sat in the House of Lords, the Law Lords. The Supreme Court obviously changes this, formally separating those two institutions. They go across the square, and they now sit in the old Middlesex Hall opposite Parliament. The aim here is, of course, to show representatively a clear separation of powers, some clear blue water between Parliament, the legislature, and the Supreme Court, the judiciary. But when it comes to the executive branch sits in the House of Commons and is derived out of the legislature. The government is made up of members of Parliament. They have constituencies who they represent, they have a vote in the passing of laws through Parliament, and so as a result of which you have not a separation of powers between the legislature and the executive, but you have a fusion of powers. Now, ultimately, Parliament does have the authority, and one of the major roles of Parliament within the UK's constitutional framework is to essentially check and hold the government to account. But they do so from inside the House of Commons, from inside Parliament itself. So, ultimately, let's think about the structure of Parliament then. Parliament is what we describe as a bicameral legislature. What does this mean? Well, it means that it is divided into two chambers. You have the House of Commons and you have the House of Lords. Similar to other legislatures in other parts of the world, again, I refer to the United States. The US legislature is, of course, Congress, at least at the federal level, and Congress has two chambers as well. It has the House of Representatives, and then it has the Senate. You can have situations where there are three chambers, something known as a tricameral legislature. I believe Spain, for example, their legislative branch has a tricameral legislature, or it might be Italy, or maybe both. But there are multiple different ways in which you can structure legislative branches. You can have some institutions that are unicameral, which have just a single chamber in which law is passed. Within this whole process, the Crown exists as a very interesting power and a very interesting check, because ultimately the United Kingdom's constitution is a monarchical one. It is a constitutional monarchy. What this means is we have monarchical authority, we have a monarchy which still plays a significant role in the administration of government, but that the monarchy is limited by the constitution, and this is of course owing to the historical relationship that the monarch has had with Parliament. as well as the sort of tumultuous years under the Stuart dynasty, the restoration of the monarchy, the limited restoration of the monarchy with the Glorious Revolution of 1688. But regardless of all of this, the Crown still plays a significant role in the administration of government. The exclusive powers which are conferred to the Crown in their authority as monarch are known as the royal prerogative. We're going to get to the royal prerogative in more detail when we examine the sources of the UK Constitution. But by constitutional convention, what we see here is that the powers of the prerogative are actually conferred not onto the monarch per se, but to members of the executive, who are then accountable to Parliament. So we sort of see how, on paper and in theory, the monarch is still severely powerful in terms of their ability to do things, in terms of their authority within the constitutional framework. This is done through the royal prerogative, but by way of constitutional convention, the powers of the prerogative are conferred onto members of the executive, who are elected members of Parliament, but who are also accountable to Parliament as well. And so this sort of plays a role as a democratic process, and it's almost a self-regulating democratic process by which the powers of the Crown still technically exist, but are limited by the powers of Parliament. The monarch will still act on the advice of the Prime Minister and the advice by the government by way of convention. They cannot act on any other advice. They cannot take any other advice outside of the advice of government. This is also a constitutional convention. And like I've said, we will get to the details of the prerogative in future lessons' time in far more detail as we go on. Speaking of the government, let's think about the executive branch. The executive branch of the UK government is also confusingly described as the government. When we look at the House of Commons, for example, we make a delineation between the government and Parliament. And when we talk about the government in that context, we're talking about the executive branch. We're talking about the Prime Minister, we're talking about the various other ministers of states, the various other departments of state, and if we're going to go even further, we're talking about the civil service and various members of the civil service as well. But obviously, when we talk about the government as in the UK government, we can also be referring to just the whole picture, the whole holistic understanding of judiciary, the legislature, Parliament, number 10 Downing Street, the Prime Minister, everybody. But when we talk about the executive branch, we're talking about a specific institution within government that we also call the government. The government has the responsibility for drafting and implementing laws, as well as drafting and implementing policy within the United Kingdom. Ultimately, the executive is usually formed when a political party wins a majority of the seats in Parliament. So when a general election is called and a general election happens, there will be a party that often wins a majority, owing to our first-past-the-post electoral system. It's supposed to give us majorities, but not always. Ultimately, we get a majority in Parliament, and then the Crown, by convention, invites the leader of that political party to form a government in their name. This isn't always the case. Of course, you have circumstances where there is not a single party with a majority. This is sometimes known as a hung parliament. The result of this is, of course, the fact that when you have multiple different parties all vying for power, and you don't just have a dual party system, then it is more likely that you're going to have hung parliaments and no single majority. Because given the fact that in the United Kingdom, you have the Conservative Party and the Labour Party, which sort of come out as strikingly the two most popular parties, but then you also have the Scottish National Party, the Liberal Democrats, you have the Greens, and you have, in previous elections, you had parties such as UKIP, etc., all of which vying for power and authority means that that takes votes away from the two larger parties, meaning that it's less likely to get a single majority. Compare this again to the United States, where de facto they have a two-party system. There are other parties that are allowed to run, but they don't get a look in. For the most part, you are either going to vote for the Republicans or you're going to vote for the Democrats. So ultimately, when you have a hung parliament, multiple parties may come together and form a government collectively. This is sometimes known as a coalition government. The last time we saw this was in 2010, between 2010 and 2015, when the Conservative Party under David Cameron teamed up with the Liberal Democrats under Nick Clegg to form a coalition government. Finally, then, we have the civil service. Now, the civil service is sort of described as the structural components of the executive branch. The reason for this, of course, is because when you talk about the implementation of policy and the enforcement of law and all of these different complicated issues, you need a very big and vast network of individuals who will work to do the running of the day-to-day implementation of government policy. So the civil service is responsible for a great variety of different tasks, from the very high-level tasks such as contributing to the drafting and the creation of legislation, to some of the smaller tasks such as the paying of benefits and pensions or the issuing of student loans. That's a civil service task that those of you who are at university studying law at the moment will obviously be familiar with, the issuance of student loans and tuition fees and things like that, the running of prisons, as well as the issuing of driving licenses. Everything from the drafting of legislation to the issuing of student loans to the issuing of driving licenses are all things done under the remit of the executive branch, i.e. under the remit of the UK civil service.